It's Kathy. I hope you're doing well. Make sure we have sound. We do. It's time for OJ. Hold on, I gotta make sure the speed is right. Can't have slow OJ. We're almost done with this video. Then we'll be on video number 442 out of 493. Oh. Ugh. Let's get started.
So under 1236 and 791, I'm going to overrule your objections. Okay.
Back to 1234. I found the page in the transcript where that was all discussed.
All right, give me the page number, please.
35340. Same objections were made and they were overruled.
Okay, 1237. I'm sorry.
What were the, I missed it.
35340 was the page cite on,
Okay.
we'll come back to that. All right, 1236.
What's objection 1236?
I show in my notes objection to 1236 and 1237.
I see 1236.
1236 is the September 12th statement by Aronson.
September 12th, that statement doesn't qualify. Under 791, I mean, it's the same problem. The evidence of a statement made that is inconsistent, that has been admitted, the prior consistent statement has to have been made before the alleged inconsistent statement, which was on June the 15th, which obviously it was not. Secondly, before the motive to fabricate has arisen. And the people's position clearly is that this was a groupie who wanted to get herself injected in the trial, and that motive existed at the time that she recontacted Detective Kilcoyne and realized it was going to be a very high-profile case, which was on July 8th, and she began to restructure her testimony to make sure that it would be relevant. That's the motive. Now, September 12th certainly is not prior to that time, nor is it prior to the June 15th prior inconsistent statement. And the people submit that it does not qualify under 791.
Submitted the early comments, Your Honor. I think the rulings are consistent.
All right, objections overruled. 1237, phone bill. Ms. Clark.
Hearsay and irrelevant.
Well, I wonder, Your Honor. Certainly I think it's very relevant because it helped to explain why Ms. Pilnick was certain that various acts occurred at different times. I think that it is, in fact, a bill from the phone company. We have been introducing these sorts of documents by stipulation and other forms. I don't think that there is any sincere challenge to the authenticity of the bill. I think it offers sufficient guarantees of trustworthiness for its admissibility. But she was, as you recall, she was very exact in recounting what events occurred at certain times, when she called her mother, when Ms. Thielander had left, and that bill corroborated the specificity with which she offered her testimony.
My recollection is that she testified that this was her phone bill.
Correct.
All right, the objection will be overruled. All right, 1240.
Hearsay objection.
That objection, well, the document, Your Honor, was offered to demonstrate Mr. Heidstra's state of mind that when there was an occasion with he and other witnesses to recount and to go through various observations from June the 13th, that there was, in fact, his state of mind not to discuss with other potential witnesses. It reinforced our claim that he was not biased, that he was not polluted by the presence or potential testimony of others, particularly with Mr. Heidstra. That has become a very real challenge. I'll simply remind the court that, as far as I understand, 4 of the first 8 names that we were given of rebuttal witnesses were witnesses seeking to rebut Mr. Heidstra. His credibility, his bias, if any, are therefore rising themselves in importance, at least from the people's version of the evidence, and this supports or attacks any suggestion that when we tried to gather people together to go over certain steps and observations, that there was no polluting.
No, it's not relevant for that purpose. It's a letter from Mr. Bailey to Mr. Heidstra. I don't know how that impacts on, that illuminates us as to Mr. Heidstra's frame of mind or his veracity or credibility at all.
All right, thank you, counsel. The objection sustained. All right, 12:50.
I'm sorry, Your Honor, we have to add 1241. It was inadvertently left off of our list. It's a 2-page statement of Mr. Heidstra.
And I'll offer the same comments and adopt those comments that I offered as respect to Ms. Aronson. Again, Mr. Heidstra's credibility will be viciously attacked, strongly attacked. I don't want to characterize it. And this is a prior consistent statement offered to rebut a claim of recent fabrication that he is fabricating at this hearing when he testified as he did.
I can assure the court that Mr. Heidstra's credibility will not be attacked viciously. In fact, we think Mr. Heidstra's testimony is very helpful to the prosecution. And in fact, what we intend to do is buttress Mr. Heidstra's testimony. Still, however, it is hearsay. It is an out-of-court statement. It was alluded to somewhat during the trial. That is what he had said previously, and he testified on the stand to what he had stated previously.
Testimony. But I certainly think, we will pick that up later in our next motion, but I certainly think that, Your Honor, if this is being offered to rebut a claim of recent fabrication, that he might have had some motive or bias in favor of Mr.
I understand that.
Hi,
but
Richard.
The objection that Mr. Darden made, though, was foundation because this was a statement taken by Detective Payne and Detective Parker, neither of which testified.
Your Honor, I believe, and I don't have a specific recollection of where this exhibit was discussed. I believe Mr. Heistra was asked about it. He then agreed that the statements that contained in that statement were accurate and that it accurately reflected what he had told them on that day. And
I'm not sure that allowing this statement in would be consistent with the court's earlier ruling on the Aronson.
And I know at the time, Your Honor, that if it was offered on page 36435, and there was no objection at that point.
46435?
36.
36. All right, I'll take a look. All right, 1253. I'm sorry, 1250. Video of 1250. Video of Mr. Simpson arriving at Rockingham. Was this the videographer who testified to this?
This is Mr. Thompson, Your Honor, the tall gentleman who put the handcuffs on Mr. Simpson. He testified and authenticated the accuracy of what was depicted there.
Ms. Clark?
Was that subject to redaction?
All the videos have been subject to redaction to that extent that they were shown for the jury.
Richard, would you ever consider intercontinental marriage?
There was the issue, I think, of the sound. There was sound in that video, which was not aired for the jury.
Asking for a friend.
So then we can do what we did with the Mazzola demonstration video and have a little post-it put on there that it should play without sound.
As I understand, the video contains only the...
Correct. Only the portion that was displayed for the jury and without sound as to both 1250 and 1251. All right, 1252 has been withdrawn. 1253.
Those videos at Rockingham, there was no
I
videographer
didn't know
called.
that.
I know.
That's crazy.
I asked if Mr. Thompson was a videographer, and my recollection was refreshed by Mr. Douglas's comment that it was Officer Thompson
Right.
who testified to the videotape.
Right.
Okay. All right, 1253, vehicle impound form filled out by John Moraz.
Your Honor, is hearsay and lack of foundation. He only filled out a small portion of that. The balance was filled out by other witnesses who were never questioned about it or able to authenticate it.
I think, Your Honor, that this is in fact a business record. It certainly carries sufficient guarantees of trustworthiness. I don't think that the people are suggesting that it is inaccurate or that it is misleading, because it is a document that was used for the purposes of the police department. Mr. Mraz did in fact identify those portions of the form in his penmanship and those portions which were not. Submit the matter on that.
The foundation was not laid for a business record at all, Your Honor, and it was incapable of being laid because they never called the appropriate witness to do so. And I would not vouch for for some of the writing on it, because it was made by people at Bertel's and based on what may have been misunderstanding between them and police officers. So no, absolutely not. I don't concede at all that it's trustworthy or reliable, and there was no adequate foundation laid with the appropriate witness to have it admitted as a business record.
But, Your Honor,
Excuse me, counsel, which portion of this form did Mr. Mraz fill out?
I recall for sure the top half, and I believe there was something toward the bottom. If I could see the form, just to refresh my recollection.
While Mr. Douglas is looking at it, will assist the court with respect to the Heitstra, pain statements for Heitstra. I've looked up the transcripts, and it's starting at page 36.
Why are you referring to a styrofoam cup, sir?
Because that's where I wrote down the numbers. If the court, to assist the court, starting at page 36438 and then going to page 36446, the entire statement is read into the record during the course of questioning Mr. Heitstra, and he adopts it, and it's read in with quotation marks.
Your Honor, this is also being offered to corroborate Mr. Mraz's state of mind.
All right, no, Mr. Douglas, my question was, what part of this document did Mr. Mraz fill out?
The top.
I would point out to the court there are many different handwritings on that document.
Go back to the transcripts. My recollection is that his testimony was that this is a document that's filled out in the regular course of business through Vertel's and the police department, that when he received the document, he had seen Detective Harrow fill out a number of the entries here. He then signed in the middle line where it says garage employees, and I think he then put down the license plate number and reviewed the rest of this material. So we're offering it as a business record with a proper foundation there. When we get to the transcript, we can, I know that he specifically testified as to which parts he filled out, but he adopted the rest of it. He explained who filled out what.
Your
He
Honor,
can't
if I-
adopt the rest of it, Your Honor. He can't vouch for someone else writing on that form or the veracity or trustworthiness of it, and they did not even attempt to lay an appropriate foundation. It's inadmissible.
It's on page 38260, Your Honor. It would also be offered as an alternative to reflect Mr. Mraz's state of mind that there was no hold then preventing or requiring that the vehicle be placed in a particular area, the secure area, and that
But
was...
really, aren't we really quibbling over something that is of little moment? The issue being, he testified he didn't see blood, and he didn't think it was being held in a secure area. I mean, that's really the import of his testimony.
The other basis for admitting this that Mr. Douglas referred to has to do with the direct examination of Detective Muldorfer at 38259, where she indicates that she conducted an investigation, interviewed the principal parties, and determined that this was the form that was filled out, and even then went into detail as to who signed what. And she authenticates this as an official business record of the garage and talks about the rules, and I put her on the rules with respect to what parts of this are supposed to be filled out and for what purposes. So we think that Detective Muldorfer's testimony at the citation of the pages we told you would be sufficient foundation. She described at length what these impound forms mean.
All right,
She's
where is,
not
excuse me, where is that?
It starts on page 38259. I think she certainly is a proper witness. It was her assignment.
Would you be allowed to complete
Wait,
with?
wait.
I think that the foundation is that she testified that she was assigned in the city attorney's office to investigate
I
these
recollect who she
garages,
is.
that she was familiar with their rules and procedures. She also proffered a series of lists talking about rules and procedures.
All right.
She authenticated this form and others and found Vertel's in violation.
Right.
So I think her testimony lays a sufficient foundation for this as a
She's
business
not the
record.
proper witness for that form. She's not the one who uses it. She's not the one who filled it out. You need to call somebody to lay a business record foundation to establish that they're familiar with the form, the manner in which it's filled out, and establish its trustworthiness, and she can't do that. She may recognize the form, but she's not familiar with the manner in which it's filled in and who has to fill it in, the people that are under a duty to do so. And the problem you have with this particular document is there are a number of people who've put in information on that form. At the very least, if the court is going to admit it, then the form should be redacted to include only that part that Mraz wrote on, to, if they want to use it for that, corroborate his testimony. But the part that is filled in by others who are under different duties than Mraz should not be admitted, because that cannot be vouched for with the testimony that we have.
All right, I'll look at the transcript.
If I may
All right,
just
1257. Ms. Clark.
passing, Your Honor, just so the court is aware, the section that Ms. Clark is concerned about is the box at the top that says "Give no special care," and I just want the court to know
Counsel,
we'll reopen
I've-
our case to put this in.
I've concluded the discussion. Thank you. All right, EDTA slides, 1257. Ms. Clark.
I'm so glad we're talking about EDTA
That was all
again.
the slides, 1257A.
Correct.
Bobby,
S. The objection, Your Honor, is 352. It's misleading and
Bobby,
confusing.
are you here?
If the court
You
will
might get
recall,
a
there were a
pickup
number
line.
of charts that were shown to Dr. Readers that the ion wars. I remember that,
The daughter wars.
yeah, the daughter wars. And I still haven't figured out why they have no sons, but they have, if they compare different
wondered that
days on some
myself.
of the charts, Your Honor, there was also a confusing juxtaposition of different results obtained at different times. And the problem that we had with all of those slides was that it was misrepresentative of the actual results that were obtained. Now, given the fact that they did not do any testing to justify the manner in which they put these together, there is no reason why Agent Martz's testimony indicating the misleading nature of those slides and the juxtaposition of those results should be disregarded. The only real testimony you have concerning how the results should be viewed and in what way they should be compared with each other is Agent Martz, because he was the one who operated the machine, he was the one who ran the tests. Dr. Readers did nothing but look at his charts and his graphs. And the problem is, as you recall, that Agent Martz testified that the machine, the column is very sensitive. It will run high one day and low another. And so you cannot compare results from one day to the results of another. In fact, you can't even compare results from the morning to the evening because the column is so sensitive. The results have to, tests have to be run at the same time, or within minutes of each other to be valid for comparison in terms of concentration of the ions. And the problem with these charts, as I recall, is that they did not do that. There were different days and different times put together in an effort to mislead and make it look as though there were discrepancies where there really weren't. And there's no basis for doing that. In fact, it's very misleading and confusing to the jury.
Mr. Glazier?
Well, I think Ms. Clark is talking about other slides. 1257 was the first set of slides. It just illustrates what the process of chromatography is, and it was each slide was gone through with Agent Martz, and if there were two charts and from two different days, that was explained to the jury. I'm not sure which. I think she's talking about some later charts, but this was all gone through with the jury. Agent Martz was allowed to explain anytime he disagreed with anything, and I don't see what the problem is.
Maybe try to see.
Well, I think it's a combination of both how the mechanism works and the specific results of testing, in this case by Agent Martz. I think we have both of those here.
Right, okay. I'm looking at A, B, C, D, E, F. I think so far so good. Through L is okay. With drawn on there. A through L is drawn on there.
All right.
I think it will, Amy, because I'm doing it before it got injured. You know what I mean? I started it right at the right time.
Here's one. 1257P. So far I've gotten through O, there's no objection. P is a problem, Your Honor, and the reason it's a problem is that it assumes something that is not in evidence. That is, the location of where 206 was taken from. Right. 206 and 207, both. No one knows exactly what area of the stain those came out of. It's never been established. This makes an assumption that one was taken out of the corner of the stain, corner of the cutout area, and that 206 came out of another spot. In other words, it makes an assumption that 206 and 207 came from different areas of the stain.
All
And
right.
we don't know that to be true at all, so it's very misleading. In fact, they might very well have been on top of each other, right next to each other, and that is important in
All right.
terms of the concentration.
May I see that, please?
Yeah, there must have been a 206, if that's possibly where it came from. There's actually a picture that showed the cutout. 207, I would agree with Ms. Clark to the extent that we don't know whether it came from the lower corner there, and that was explained by Mark said, I don't know if it came from that corner, but it came from the larger cutout. So that's all that illustrates. I think that was
Right, I think Bob's correct. The problem that we have, though, is that as it's depicted there, it's very misleading, because a jury's not going to remember how Agent Marks explained it or didn't explain it. They're going to have a big picture back there, or during argument, that purports to place 207 where it's never been established it was. And that is an important point. It's not nitpicking, because where 207 came from in relation to 206 is important in terms of the concentration of blood.
But it was all explained. I mean, there's nothing misleading about it. They were told that we don't know exactly where it came from the cutout. It illustrates that it was part of the cutout.
All right, but this slide can be modified, correct?
Sure.
If Mr. Glazer would take out 207, to take it out of the photograph, then I wouldn't have any objection.
All right. I think what we can do is label that 207 came from somewhere in the green area.
Okay.
And
All
take
right.
that box out.
Take that box out.
Great.
All right. This is 1257P. Aren't you keeping track of these things?
I lost that, Your Honor.
All right. All right, Captain, we're going to take our recess at this point, and we'll stand in recess until 2 o'clock.
Your Honor, just some clarification, so we can know for this afternoon. You have another motion on this afternoon.
We have to finish this first.
Okay, and not only to finish this, we also have to finish the scope of rebuttal. And we have specific discovery problems
Right.
as well that must be resolved today. Because as you know, they want to commence their case on Monday. And they had really...
Counsel, you don't need to argue it now. I'm aware of all these matters we have to take up, and we'll start at 2 o'clock. But we will finish this. All right. All right, back on the record in the Simpson matter. All parties are again present. Jury is not present. Where were we? 1251-ish. And counsel who are here for the motion regarding access to tapes, et cetera, I've got to finish this first. So if you want to take an hour and get a cup of coffee, be my guest. Yes. All right, Ms. Clark, where were we? We had gone through P, as I recollect.
That's right, Your Honor. We got up to 1257Q, and I asked for Xerox copies from Deidre to look at over the lunch hour. Unfortunately, the Xerox copies don't tell me the date and the stuff that I need to know to identify the charts. So I thought it was a good idea at the time, but it didn't quite pan out. So if I could look at the originals again to see if I could get a little more detail, unless Mr. Glazer could tell me offhand, you know?
No, I don't have.
Thank you, Your Honor.
We don't have, I've excused our Elmo operator. I don't need to see it on the Elmo.
No, I do, Your Honor. I can't, because it's too small. And I can't tell which charts they are. I can't read.
Here, let me give you my magnifying glass. No, Mr. Ormond, I gave the rest of the day off. I didn't think we'd be using that.
There's no reason to think that we would. Actually, Henry Lee gave me his. I should put it down. marked. That will...
Do you want to pass this whole series?
Yes. Come back.
All right, how about 1261? Bar chart, EDTA. All right, objections withdrawn to 1261, 1263. A letter from the DA's office to Special Agent Roger Martz with lots of writing on it.
This is the one.
Do we have a clean copy of that?
Yeah, we can substitute a clean copy.
He was objecting that it's hearsay and it's irrelevant.
I would have to cut, I can cut the ceiling out maybe. Hold on. It's not going to enlarge. It's a square video.
Objecting that it's hearsay and it's irrelevant, Your Honor. I think it was offered to show bias.
I can
on
like
the part of
cut
the
the
witness.
ceiling out. We don't need the
That would
ceiling.
go to the witness's state of mind. It would go to the writer's state of
Is
mind.
that better?
Assuming that it showed any bias, which it doesn't. It asked for the receiver of the letter to detect the presence or absence of EDTA without indicating that a particular result should be obtained.
Mr. Blazer?
But that same objection was made at 38627 of the transcript. It was overruled at that time. I don't know if there's anything new about it.
Well, I overruled its, I allowed its use for examination of that witness, but that witness was not the author of the letter.
No, that's correct, but it demonstrates what he was told. This is what we want you to do, and it's relevant to his state of mind. It's not offered for the truth of the matter stated, certainly.
All right, the objection will be sustained. All right, 1267. The
It's cutting off their heads.
food iron absorption article,
This was the,
1267.
right, this was the article that had been referred to by Dr. Reeders as, in his attempt to say that there had been a study that had been used to determine the average daily amount of EDTA that would be found. But he wound up having to concede that that, in fact, was not shown by the study at all. The study was for a different purpose, and it was, what they did was they injected EDTA for the purpose of determining what would be left after certain periods of time, but that does nothing to indicate what trace amounts would be found if everyone's blood was tested for various types of EDTA, so it's very misleading. I believe the court initially had ruled that he could not bring that article out and could not be questioned about it, and then Dr. Reeders just kept talking about it, basically. I mean, he wasn't even listening to my questions. So I think the court earlier ruled that it could not be used, and we simply urged the court not to allow its admission. It is irrelevant, it is misleading and confusing, as Agent Martz indicated as well, when he had to go back and try and unravel it.
Ms. Clark's confused. She's talking about 1268. 1267 is the article about the average person, the maximum daily intake of EDTA in a diet would be 50 milligrams, and that would lead to a certain level in the blood. But as to both of those exhibits, Agent Martz testified, in fact, he was the one that was asked if that's the article he relied on when he gave that figure of 50 milligrams a day, and he said yes, it was. 1268, the article, the absorption article that she was talking about, also was testified to extensively by both Dr. Reeders and Mr. Martz. They both relied on it. They relied on it for different purposes, but it was extensively discussed, identified by both of them, and relied on by both of them. They disputed what it showed, certainly, but it doesn't detract from the fact that they both relied on it.
Well, the fact that they both relied on it, though, the fact that these are both scientific articles out of scientific journals, I mean, isn't there a danger here that I mean, Dr. Reeders testified, Agent Martz testified, and you have exhibits that say what their testimony was. I mean, why do we need these articles?
Well,
I mean, do you seriously expect the jury to go back and to read scientific journal articles?
I don't know. I would hope not, but I mean, they were referred to. They were read in. Parts of them were read into the record. If they have any confusion about which doctor was, whether Dr. Reeders was right or Agent Martz was right, and what those articles said, they might want to refer to them. The fact that they probably won't, I don't think, is a reason to not have them admitted. And we might want to make reference to them too in argument.
With respect to, I'm sorry to interrupt, but with respect to 1267, that was, I just got my memory refreshed. That was the FDA listing of EDTA amounts in food, and the people withdraw their objection to that. I've just been shown the reference in transcript. But we maintain our, but Mr. Blazer is correct, 1268 is the one that we have the objection to, because, and that is completely misleading. It was, Dr. Reeders attempted to use that article to buttress his position as to what if any, amount should be found in people on a normal, regular person on a daily basis. And in fact, it does not direct itself to that at all, which is why it's so misleading and confusing, and not to mention
All right,
very
this is the
complicated.
article that deals with the injection of EDTA.
That's right, 1268 does. I'm sorry. So,
All right, not only are they confusing scientific articles, we're confused as to which one is which, correct?
I'm not.
All right, well, Ms. Clark and I are confused as to which one is which. All right, I will sustain the objections being irrelevant because this does deal with injected EDTA, not ingested EDTA. All right, next, Cambridge Isotope Laboratories, 2 pages. This is the catalog that shows that EDTA compounds, as research compounds for testing and comparison purposes, correct?
No, that there was an internal standard readily
Right.
available.
Ms. Clark?
the objection I had down was insufficient foundation and hearsay. And I can't remember what Dr. Reeders did to lay the foundation for it now. It escapes me.
Testify about it at all. It was Agent March who was shown the catalog, testified that he recognized this is a catalog from Cambridge, and looked at that page in the catalog and said, yes, that does look like an internal standard that could be used, and described what the price was.
$250 if I recollect.
Right,
Something like that.
right.
All right. Objection will be overruled. All right, 1271 A through C, ion counts.
Yeah, maybe I can shortcut this. The third slide was a demonstration slide that I did adjusting some of the quantities. It doesn't reflect actual test result. It reflects those multiplied by various numbers. I have no objection to that not being given to the jury, but I certainly think we're entitled to argue that. I mean, that's something we could present an argument. But since it didn't result, any specific results from any tests, I have no objection to withdrawing that with the understanding that we can still make the argument, of course, and show it in argument.
Ms. Clark?
Okay, and let me make sure, if I can look in the transcript very quickly, for A and B, I may withdraw.
All right.
Let me see.
I believe those were just straight charts that Mark's identified.
These are the charts around that have the different days.
Yeah, they were objected to on that ground. I think we added the dates to them.
Do you need a magnifying glass again?
No, I don't, thank you, Your Honor. I probably should get glasses. These, as to A, Your Honor, we have here the juxtaposition of February 22nd and February 28th for the same.
Are they marked as such?
They are, and I'm not disputing that they aren't, but with respect to B, no, these okay then. Yeah. Yeah, if we just pass these, I may withdraw the objection. I wanted to see what Agent Martz said about these 2 slides, and if we don't have to argue an objection, I'd like not to. I have, Ms. Martinez will find the part.
Okay, then we can move on to my second favorite objection. Socks.
It's just a brown sock. And the relevance would be
Socks.
socks. Yeah, they're not the same as the ones in evidence. So what's relevant?
No, the exclusive relevance of the sock was simply to coincide with the testimony of Herb McDonald to enable him to explain what surface 1 is, surface 2, and surface 3. If it isn't obvious to this jury that it isn't the same sock and it's being only for that purpose, it would be truly extraordinary.
I don't even think this needs to go into the jury since everybody knows what socks are.
Fine, Your Honor.
Okay, withdrawn. Okay, we actually skip a whole page. 1317.
Oh, I'm sorry, so 1279, is it? What?
Withdrawn.
Withdrawn.
All right, 1317.
Yes, Your Honor, I like you handling that. That was Michelle Kessler, who testified. This was an item of handwritten notes by Gregory Matheson, which was shown to the witness for the purposes of refreshing her recollection. I just reread the transcript, relevant transcript sections. And in fact, it did refresh her recollection that they had had certain meetings shortly after the crime scene was processed on the 13th of June regarding case security. That's all it was used for. The document itself is not an official form. It's not a business record. I don't know why it's being offered.
I'm just curious, was this considered listed as one of the objected items yesterday? Move forward.
All right, withdrawn. Mr. Robinson, get that? All right, thank you. 1318.
Your Honor, this was the memorandum from Chief Gates that I believe was 24 years old.
No, it's older than that. It's from Assistant Chief Gates.
Oh, it was? Okay. And I also just checked the transcript on that, and there
We'll
was...
withdraw it. We'll withdraw
Okay.
it. Withdrawn, although it was a very interesting document.
Aren't they all? 1319.
Your Honor, I make the same objection that I previously argued this morning with respect to the collection.
You've already admitted
memos.
this.
It absolutely
Sorry,
was
this is the
not a
same
very
collection.
interesting document, sir. That was a lie,
Isn't this
perjury,
collection and preservation of body
contempt,
fluids?
Yes.
sanctions.
All right, 1320.
Is the summary that was done in preparation for the Griffin hearing, which was a typewritten summary. This particular document was not a business record, and it was generated by Greg Matheson. There's a very similar or identical document, I believe, that was actually testified to by Greg Matheson, which came in since he was the witness that created it. But this particular version of it, typewritten version, is not, cannot be authenticated and not fall within any exception to the hearsay rule.
Your Honor, my understanding, my recollection was that she did authenticate it. In fact, it was authenticated twice. She testified to this typed version of it at that hearing before Your Honor last summer, and it was the same report that was shown to her on the witness stand in front of the jury. And it was a typed version that she participated in the preparation of. I disagree with Mr. Goldberg's recollection of this.
All right, anything else?
No, I think the foundation is there, the authentication is there.
Just ask the court to reread the transcript, because this particular one was prepared by Mr. Matheson. She was present, but during when the handwritten version was made, and the handwritten version, as I recall, is in evidence.
All right. All right, the objection will be overruled.
Objection to what?
Overruled. 1329. This is the photograph of 112 blood spot.
This was a substitution question.
Your Honor, on 1326B, according to my notes from our discussions yesterday, the defense was going to withdraw that.
That's correct. 1326B is withdrawn. All right, 1329.
These were items that the prosecution, 1329 and 1330, the prosecution wanted to have permission to cross-reference and put Post-its on. Other than that, we didn't have an objection to them.
All right, do you know what cross-reference that should be to?
Well, I think that the cross-reference to 1330 is 1098, and I don't have the cross-reference for 1329 yet.
All right. 1330. This is the one, this is an Elmo printout where the detail on the door sill is lost in the Elmo process. So we are going to cross-reference this to the actual photograph. Do we have the number to cross-reference that to? And I can put a Post-it on it?
1330, Your Honor?
1330.
That's the one that, according to my notes...
1098. 1098. All right. All right, and Mr. Goldberg, your staff will prepare a label indicating cross-reference People's Exhibit 1098. Okay. Okay, now I have objections 1331 through 1336.
beginning.
All right, these are all photographs from Chicago.
And we can go back to the ETA whenever you want to. Yeah, we have, the people have, I think, similar photographs, if I could see them.
Come on, Marcia, you're wasting everybody's time. Our precious time is being wasted. Why can't you be more like that Texas judge?
No deputies, and in return for that, Mr. Douglas, in case you will not object to the people's exhibits, let me name for the record some of them. 581A, B, C, D. E, F, F, G, H, I, J, K.
All right, objections withdrawn.
Withdrawn in return for that agreement, sir.
They're the same picture, so I don't object to the entire set coming in.
Terrific.
Oh, and the big one? Did you also read the book of the watch log in?
I hope so.
Yes, no, thank you.
All right. We are going to cross-reference 1337 and also 1337C. Mr. Goldberg, that was your suggestion?
1337C.
Right. Did we get another exhibit number?
We don't have that yet, but we will get that.
All right. Okay, then we skip to page 18, 1360A.
We have 1341. I haven't known about cross-referencing that, but that might be difficult. I think that's one of Mr. Lee's boards.
All right, I don't think either side has any problem cross-referencing
Okay.
similar exhibits. Okay.
Okay, and I will bring those to the side.
All right, 1360A, which appear to be 2 pages of Gary Sims' notes.
Yes, these were, it was a page of Gary Sims' notes that notated some transfers on bindles, and objections were sustained to that when the defense tried to elicit from Dr. Lee what was stated in the notes.
Defense?
My argument is that these notes are notes that Dr. Lee testified that he would generally rely upon from other experts in the field. They're the laboratory notes of the analysis of the bindle. And they document that Gary Sims said there was a cross-transfer. So I think that under the...
Well, is there any dispute, given what we've seen from the photographs, that there were cross-transfers?
No, there's no dispute that there's a cross-transfer, but what's significant is that Gary Sims noted it, and when he noted it. That is a significant evidentiary point.
Mr. Goldberg?
Your Honor, I thought we were not going to relitigate issues that had already been resolved adversely to the party, and I've been trying to stick to that. This isn't an issue where I'm not positive. I think we may have gone to sidebar, but at any rate, the court did make a ruling and several times sustained objections. We would like the hearsay rule to be enforced. It is hearsay. There is no authentication for it.
All right, objection sustained. All right, 1363.
Your Honor, this was an article that I objected to, and it's our position that when you are using an article from a scholarly treatise, the article itself doesn't come in. However, for tactical reasons, people are withdrawing our objection to this particular exhibit.
All right. 1364, Ms. Clark.
Yes, ma'am. Standing in for Mr. Darden. Those were the questions propounded to Officer Furman by Laura McKinney. The problem with it is, Your Honor, that it goes far beyond the material deemed admissible by the court and basically makes reference to what I believe to be sections of the tapes that were deemed inadmissible or responses. Or if not deemed inadmissible, were not requested to be admitted by the defense and not known to the jury. So the problem is really that the questions go far beyond the testimony that was deemed admissible by the court. I think it would cause the jury to speculate about what else was said and the balance of the conversations that were neither proffered by the defense nor ruled admissible by the court.
Your Honor, I take that as being a 352 objection. I do think, however, that it is very germane to the question of what Ms. McKinney was trying to do. Was she simply working on a work of fiction? Was there any realistic components to any of that? I think that the colloquy suggested by those sheets in that exhibit reinforce our claim that when any words were spoken by Mr. Furman, and the 42 times that he uttered the N-word, he was not doing so in any sort of character. Rather, he was reflecting more his own personal viewpoints, because the questions speak to different issues and areas of general concern and make it clear that he's not being asked certain questions in any sort of a theatrical or fictional context. I think that's going to be a very important aspect for the juror's assessment of the value of her testimony in this case.
But, Your Honor, the problem I have with it is this. Ms. McKinney was clearly capable of being very articulate in framing her answers to demonstrate what the defense wanted her to demonstrate, which is that he was talking in the first person and not for any fictional character when he used racial epithets. If this set of questions is being asked for to be admitted for that purpose, to establish that he was speaking for himself when he uttered those epithets, then the defense does not need them, because the people will never argue to the contrary. And if anyone needs any further assurance of that, let me state it on the record. I am not going to argue to this jury, nor will I ever tell anyone, that I think the racial epithets were used in a fictional capacity by Mr. Furman. The problem, and so that being given, that concession being given, and will be repeated to this jury, there is no reason to admit these questions, which I think will cause the jury to speculate about what else they talked about that are way outside the bounds.
If counsel is willing, because Your Honor, the negative is not sufficient for our purposes, because the jurors on their own may associate the fact that there's a screenplay, that it's a fictional work based on fact, as being suggestive of more. If counsel were willing to stipulate that, in fact, these were factual statements of his, rather than saying, I'm not going to argue that it's fictional. I want the reverse of that. I want her to stipulate, and then I'll withdraw the exhibit, that, in fact, these were expressions of his own viewpoint and were not part of any fictionalized role-playing, because the jurors can, on their own, without the assistance of counsel, interpret the answers and the conversations in a manner that will not be accurate and will be misleading. And this exhibit helps to place that in a better context. We're talking about issues of general concern. We're talking specifically about matters that we're dealing with, general attitudinal points of view. There's no question suggesting play a role and tell me what someone would say. And I am fearful that the jury on their own may interpret something that's not true.
Well, the proffered stipulation as framed goes a little too far. It's clear from reading the transcript, as the court knows, that there were a lot of times that they were actively engaging in setting up fictional things. For example, the example of a cover-up that Ms. McKinney kept trying to get before the jury was an example of a piece of fiction that she and Mark Furman were working on. That was the situation where a suspect had been subjected to the chokehold or to some beating, and the female officer was expected to cover it up. That was the piece of fiction that they were working on, that she was trying to get before the jury. Nevertheless, what I'm getting at, Your Honor, is this. The defense seeks to have the jury know that when he used racial epithets, he did so on his own because that's the way he felt. I'm not arguing to the contrary. This set of questions goes far beyond that purpose, going into all kinds of different areas and his viewpoints about them. And one of the questions even will assume facts not in evidence because it discusses his response to a socio-political question that was put to him in an earlier tape. So I would simply urge the court that it's way overbroad for the stated purpose.
All right. I'm going to sustain the objection under 352 because it does, in fact, deal with many situations that are not relevant to the issues before the court.
Possibly, Your Honor, the court reconsider and have us redact those areas that were not, in fact, discussed in testimony.
No. All right. 1368. A good number to end on. Yes, it is.
Your Honor, 1365, is that duplicative? I'm having trouble.
That was withdrawn.
Okay, withdrawn. Is 1368, what we just need to do is make sure that that is the one that was approved by the court for admission.
I believe it is.
Okay,
Mr.
with
Harris
that-
indicates that that is true.
If we can simply make sure there's nothing else on that tape except what the court deemed admissible, then there's...
Ms. Clark is welcome to sit here and listen to the entire tape to satisfy herself.
All right, thank you.
Okay.
If we could go back then to what we earlier asked, as to the EDTA, Your Honor,
Yes.
1271? Now I recall. As to 1271A, in which the dates are labeled, there's no objection. As to 1271B, here's the problem, Your Honor. What it shows is that it shows the gate and the positive control on February 28th, and it shows them to be very different in amount. And it's misleading because the reason for the difference in amount, which is what Agent Martz said, and I'm going to show the court the area of the transcript where he's asked about this, is that this was again a situation in which one was run in the morning, and then there were a lot of runs, like 30 runs that day, and then one was run at the end of the day. The column became desensitized, and so you had vastly disparate readings because of that. This chart makes no effort to explain that, and to the contrary, makes it is very misleading because it does not anywhere indicate that there were some 30 runs in between and hours in between, which accounts for the discrepancy in the amounts, given the sensitivity of the column. And I have for the court the relevant transcript portions.
All right, I recollect this.
Karen, yes, thank you, Zach.
it-
Thank you so much.
It should be our argument that there was complete testimony about this, and his offered explanation. Our position is that that may account for some of it, but it also shows the imprecision of this methodology that he used. So it's been fully explained to the jury. It's not misleading at all. I mean, they've been told about it.
All right, and what about C? You're withdrawing that?
Yeah, with the understanding that I stated.
All right.
We can argue that certainly.
Well, we should argue that later. I think we should argue that now. But as to B, the problem is that if a juror gets the chart, all they're going to do is see a very misleading chart that doesn't indicate the difference in the time of day, the separation by runs. It's very misleading. And
All right, I think Mr. Blazer's point, though, on this is well taken, that it does show the imprecision of this type of testing, that if it differs by when the result differs by when you did it in the day and what run it was, something that you should think about.
well, that's true. Then why don't we simply ask that it be modified to indicate that one was the different times that they were run? Because that is available information to Mr. Blazer. So,
All of their charts are different times and different runs. Then we should
I
exclude-
understand that, counsel. I just ruled in your favor.
Thank you.
You're welcome. All right. Objections are overruled as to A and B, and C is withdrawn. All right, what else do we have? Other than the ones that we've cited to transcript, that the court has to look for the transcript.
There was, okay, 1224 was the hair and fiber slides that I provided the transcript reference before lunch.
right. And we did have a sidebar on that issue. I don't think that prevents the court from considering the subject matter again, that people renew their objection. I still think that it is misleading in that it tends to, it
I'm sorry,
actually...
we're talking about 1224?
That's right, Your Honor.
All right.
It contradicts the testimony of the witness. In stating that there are no hairs consistent with O.J. Simpson on the Rockingham glove, that is inconsistent with the testimony of the witness.
Okay, I'll take a look at the transcript. So I have still to rule on 1036, 1043, 1052, 1132, 1170, 1224, 1241, 12:53. And that's it. Mr. Douglas.
Your Honor, it doesn't matter. That dovetails into the argument that Mr. Blazer is going to give concerning the proper scope of rebuttal.
No, I just want to make sure that we concur that those are the exhibits that remain to be ruled upon as soon as the court has the opportunity to review the transcripts.
Back and forth with my understanding, Your Honor, yes.
All right, Ms. Clark?
Yes, Your Honor.
Okay, good. That was rather painless for 400 exhibits.
We have to mark some exhibits, Your Honor. We had to renumber them. Ms. Robertson informed me that I had incorrectly marked one, and I forgot to bring down the sheet. I think I forgot to bring down the sheet that says what the renumbering needs to be. I need to do it on the record.
601, 601, 602. If you get transfer ticket, it should be 602 A to B instead of 601 A to B.
So if I could, Your Honor, the magnetic board that was previously marked as 601 A through E, which was the interior of the Bronco, remarked as 602 A through B.
So, Mark.
Thank you. Also, the videotapes of the exercise videos,
Which
we have the
one?
redacted versions here,
The commercial version or the
the outtakes.
studio version, the outtakes?
Outtakes. 521A, they've been redacted, I think, as requested earlier. And then the motivational speech for Juice Plus, 522A.
All right, so Mark.
Your Honor, at a time of convenience, can Mr. Harris be allowed to check those?
Absolutely.
Thank you.
All right, Mr. Douglas, you had something else you wanted to address the court on?
Yes, I do,
And
Your
why
Honor.
don't we just right now set an agenda for the things we need to cover this afternoon? What are the matters you think we need to resolve?
Your
this
Honor, we have to
afternoon?
resolve the question of the rebuttal list that we were given today. I would like to speak concerning the lay witnesses, Mr. Neufeld, about the scientific witnesses and the problems attendant to each. We have the matter to discuss in terms of our motion to limit the proper scope of rebuttal. As a corollary to both of those motions is the broader question of the discovery or lack thereof, and what impact, if any, it will have on our ability to begin the rebuttal case on Monday.
All right, Ms. Clark, this morning I saw a list of rebuttal witnesses go flying across my desk,
Right.
correct? Who do you anticipate as your witnesses for Monday, Tuesday, and Wednesday?
I didn't bring down any of the rebuttal list, because I would find out the exhibit stuff.
All right, I think some of that belongs to the court.
Yes, I know this.
All right.
The, I need to get a copy of my stuff. I can tell the court and counsel that we intend to begin with the glove photographs. So it will be all of those photographers, in addition to a representative of NBC or a stipulation to NBC video clips of the dissenting gloves.
I played them. I played his exercise tapes.
Are we going to see Mr. Rubin again
Yes, we are.
after this?
Yes, at the conclusion of it all. And all of the photographs that we intend to present have been examined by him and authenticated by him already.
Okay, have the photographs all been given to the defense?
Yes.
No. There are other photographs we've been told we're to get. I was just handed photographs that you ordered turned over a week ago that are the key ones that I've been told that they will probably use. We just got them. And I've asked every single day for them, and now I get them this afternoon. It's Friday afternoon. I can't send them out across the country. They're not going to. This is completely impossible for us to try and prepare for Mr. Rubin on Monday when we get these pictures on Friday. And we have the whole scope argument as well.
You know, I'm at a loss here. I'm not the one who did the discovery of the glove photo, so I can't respond to counsel. I don't know. As I understood it, everything went over to the defendant.
All right, why don't we do this? Let's do this. As far as this issue is concerned, get your stuff, get Mr. Hodgman and Mr. Yokelson down here. Let's resolve the discovery issues for the rebuttal case this afternoon. I want to launch into, I want to give Mr. Regwan and Mr. Schwartz their hearing regarding the Furman tapes, and I take it, I don't believe either of you have any further interest in that particular aspect, do you?
other than to indicate to the court, can I indicate to the court our position now that I can go upstairs and get to work on this discovery?
Sure.
Our position is that the tape should be released, and we urge that there be a full public viewing and hearing of all of the matters contained on them for further examination and review.
All right. Mr. Douglas?
Your Honor, we would defer to the position taken by Mrs. Regwan and Schwartz. We feel they are in the best position to assess and to comment on the admissibility or the release of those documents.
All right.
But, Your Honor, respectfully, I'd like to get back to work, particularly given some of the things that have been said just now. And if the court can indulge us, I would like to resolve these discovery matters before we launch into the other things so that we can
Well,
get out of here.
counsel, here's the problem. I need to clear off all of the exhibits I got here. I need to give them back to Mrs. Robertson so she can sort through what's been admitted, what's been kept out, and then she has to pull out those things I need to reconsider, or once I get the transcript. So I need to take some time with my staff to accomplish this. In the meantime, I thought I would at least give, because we had scheduled this matter at 2 o'clock. We're already an hour behind schedule because I did not anticipate this hearing today. We have the city attorney, Mr. Hahn, here, so I'd like to at least hear that argument, and I propose to limit it to half an hour. That'll give Ms. Clark enough time to track down Mr. Hodgman, Mr. Yokelson, get down here, let's settle these discovery matters. I am concerned about the photographs of the gloves because I did order those turned over last week, or earlier this week, whenever it was.
And, Your Honor, as part of that direction, can you ask that they be prepared to inform us of the next 3 days of witnesses in the order?
She's just given me, Ms. Clark just gave me glove photo persons, NBC video persons, and Mr. Rubin.
How
I don't have 3 days left.
dare him?
Probably not.
The balls on that attorney to just say that. And Marsha's standing there and she just rolled with it like nothing happened. He just asked for the next 3 days of witnesses from her. Yo, go. Don't say that, Kathy. Don't say that. How dare he? She's been pounding the walls asking for that from the defense team for almost their whole case in chief. The judge didn't enforce it. No one listened to her. Everybody ignored her like she wasn't even speaking. Oh, I'm so mad. I'm so mad for her right now.
Why don't you get started on that? All right, we'll take 5 minutes. I don't want to clear the courtroom, Deputy Judge. I just want to take 5 minutes to clear the exhibits off the bench. Well, the production of certain audio tapes and transcriptions of those audio tapes that we have come to refer to as the quote-unquote Furman tapes. Those tapes, the originals and the transcript, and a transcript prepared by the District Attorney's Office, and a transcript, partial transcripts that have been prepared by the defense, are in the possession of the court. The tapes in a redacted copied form were considered by this court with regard to the use and admissibility of those tapes as they pertain to the testimony of Ms. McKinney. The unredacted tapes were listened to and the transcripts were read by another court as to another issue in Department 123, the Honorable John Reed. So those matters have been completely and fully examined by the court for purposes of rulings in this case. The party which produced those documents, Laura Hart McKinney, represented by counsel, has had, at the time that these tapes and transcripts were produced in court, asked for the protection of this court, asked for the assistance of this court in the form of a protective order so that these materials would not be disseminated beyond the confines of the real parties and interests, the prosecution and the defense and the court, for the legitimate purposes that those items were originally sought. We have now, because of the overwhelming public interest in these matters, been requested by various parties, the Los Angeles City Attorney's Office, representing, I believe, the Los Angeles Police Commission, and the American Civil Liberties Union, amongst other parties, have requested that the court make these materials available to the public without any further restrictions. I'll hear first from counsel for Ms. McKinney, and counsel, I'll also allow you to conclude the argument. All right, Mr. Schwartz, good afternoon, sir. And I would like to conclude this part of the oral presentation by 3:30-ish.
Okay. Thank you, Your Honor. Good afternoon. May it please the court. 10 years ago, Laura Hart McKinney began a fact-finding expedition for the purposes of gathering information to be used in a screenplay to be made into a motion picture, and in a novel. She worked for 10 years on these projects, and she recently completed the screenplay, and the novel is nearly complete. These end products represent the fruits of 10 years' worth of intense physical and creative labor. And the reason why we're here today, Your Honor, is to determine who should control the custody and the use of these materials. Is it going to be the exclusive and proper owner of these materials, or is it going to be the city entities, or will it be a special interest group that has its own agenda? We're opposing all these motions, Your Honor, for 5 reasons. The first ground for our opposition is the fact that the moving parties don't have standing to seek the relief they have requested. The second basis for opposition is that the relief requested would violate my client's rights as protected under the Copyright Act of 1976. The third basis for opposition is based on my client's privileges that are provided for in the California Constitution, Article 1, Section 2, namely the Shield Law. The fourth basis for opposition is that the relief requested would result in an unconstitutional taking in violation of my client's Fifth Amendment rights, specifically with regard to the Just Compensation Clause of the United States Constitution made applicable to the states by the 14th Amendment. And finally, the last basis for our opposition is more of a factual argument than a legal argument, and that is to say that the interests to be served by the relief requested have already been served by the cooperation of my client as rendered previously. So that said, I'll now address our first ground for opposition, standing. According to Yancey versus American Savings and Loan Association, California law is in accordance with the federal law of standing and treating standing as a jurisdictional requirement. Valley Forge versus Americans United is a seminal case on standing, holds that the doctrine of standing requires a party seeking to invoke the court's authority to show that they have personally suffered an actual or threatened injury as a result of the conduct of the defendant. Now, first of all, my client is not a defendant in this action. She is a non-party witness who was brought here against her will by a subpoena, as the court noted previously. And she has not engaged in any conduct that would ultimately threaten injury or actually cause injury to any of the moving parties. And therefore, the moving parties are unable to show any basis for standing according to the Valley Forge Authority. And with specific respect to the ACLU as a moving party, the Sierra Club case, another seminal case, Sierra Club versus Morton, provides specific guidance. It says standing does not exist merely because a party claims to be acting as a representative of the public interest, nor will standing be established by way of an organizational interest in the problem. And yet that's exactly why the ACLU is here. They say that they're representing the public interest, but that's exactly the kind of abuse that Sierra Club has decided to protect against. And so they have 2 reasons why they shouldn't have standing. And I know the court has granted the ACLU the right to submit motions previously, but that perhaps standing wasn't challenged in those cases, but we're challenging their standing to make this motion today. The second basis for opposition is copyright law. The moving parties have suggested that my client doesn't have a copyright interest in the audio tapes and the corresponding transcripts. And they proffered to this court the authority known as the State of Hemingway versus Random House, which is a New York State case, persuasive authority, if it's even an authority at all, which was decided in 1968.
Predates the 76 Copyright Act.
Precisely. And so when they say that there's no statutory basis for a copyright protection in an audio tape, and there's only common law copyright interest, they're wrong. That authority is obsolete. Specifically, the Copyright Act of 1976 in Section 102A7 provides that sound recordings qualify for copyright protection. It says works of authorship include ... sound recordings. And in Section 101 of the Copyright Act, it says that sound recordings are defined as, quote, works that result from the fixation of a series of musical, spoken, or other sounds, regardless of the nature of the material objects, such as discs, tapes, or other phonorecords in which they are embodied. And so clearly, when my client affixed Mr. Furman's vocal sounds into a tape recording, she acquired a copyright interest immediately in the recording. And they've also hinted that just because Mark Furman has answered certain questions...
materials. Otherwise, the public's always going to say, did you get everything that was on these tapes? Did you investigate everything that was on these tapes? Is there a possibility that you may have missed some information that could have led to a criminal investigation or led to investigations that would have implicated other police officers? What are you trying to cover up? What have you missed? We need to reassure the public that we've done everything possible to get to the bottom of these outrageous statements. The public needs to be convinced that the police department is serious, that we want to eliminate racism in the department, we want to eliminate misconduct in the police department, we will not tolerate it. In order to do that, we need to do a thorough investigation. Obviously, the court is concerned about these property interests, but think of it as in any other situation. If the court came into possession of evidence of a crime or criminal misconduct, obviously the police department would have the right to come to the court and say, we need that material, Your Honor. We need the court to turn that material over to us so that we can do a proper investigation. The fact that this is intellectual property doesn't change what it is when you come right down to it. It is evidence of possible police misconduct and possible criminal activity. Under those circumstances, the police commission has not only the right, but the duty to get those materials and investigate these charges fully.
All right, Mr. Hahn, does the police commission
Is
have
that
independent
duty?
subpoena power?
Yes.
All right, have you attempted to subpoena these matters?
Yes. We have served Ms. McKinney with a subpoena from the police commission for these materials.
All right, and when is that set for adjudication?
It's set for adjudication September 12th. She's been ordered to appear before the Police Commission on September 12th. We've been informed by Ms. McKinney's lawyers that they intend to file a motion to quash.
All right. Thank you, counsel. Mr. Morrell.
Good afternoon, Your Honor. Douglas Morrell, M-I-R-E-L-L, representing the ACLU Foundation of Southern California. With me in court today is, among others, the legal director of the ACLU Foundation, Mark Rosenbaum. Your Honor, I am mindful of the court's timing, and I realize that this is a collateral matter. And
it's been a long week.
I know it has. I appreciate that, Your Honor, and I don't really intend at all to make it any longer than it absolutely has to be. But there are obviously several issues that I want to be sure that the court understands and that I have an opportunity to address. First, let me just say what are the parameters of what it is that we're seeking. We are seeking access on behalf of the general public and the press, and by the way, I should note that Ms. Sager is here as well, and she may wish to address these issues briefly with the court. We are seeking access to the transcripts and tapes that were presented to the court and were considered by the court, and which are the subject of the court's order of August 31st. We are also seeking access to all submissions that were related to the defense's proffer, as well, including the submissions by Ms. McKinney's attorneys, if any, by the city attorney, by Mr. Munger. All of that is by way of fulfilling what we think is a fundamental right, which is the right to ensure that the public has access to all aspects of what is a public trial. And these documents, like many of the documents we've talked to the court about before, including the transcripts of the juror dismissal hearings, these transcripts are every bit as much public records of a public trial and are public property in every bit as much a way as anything else that we've ever addressed with the court. I want to apologize first, Your Honor, for not having any written response to the papers that were submitted at the very end of the day yesterday and that we did not see until after the close of business yesterday. To the extent that the court has any lingering concerns that we can address in writing, I'd be happy to do so, work on it over the weekend, get you something on Monday. But let me address first some of the very crucial, important issues that are totally ignored in the opposition papers that arrived yesterday. First and foremost, the public record character of these transcripts and tapes. Ms. McKinney's opposition, I think, is notable for its failure to address, much less contest, the clear and unrefuted line of U.S. Supreme Court authorities that we have provided to this court that indisputably provide that public records that records of a trial are public records, that their sealing is presumptively unconstitutional, and that their non-disclosure can only be justified where it is essential, and those words are within the court's opinions, essential to preserve higher values and is narrowly tailored to serve that interest. Nowhere in their briefing are those cases addressed. Nowhere is this issue directly confronted. And I think I know why. The answer is that they have no argument in refutation to the concept that evidence that is presented to the court, that is considered by the court in reaching adjudications that have already been made, is evidence that is public information, and the public has a right to it, just as they have a right to attend this trial, just as they have a right to participate in the process of determining whether or not what is going on here is an appropriate exercise of the court's power, is an appropriate fulfillment of the rights, duties, obligations of all parties. Next, second issue that's unaddressed. The transcripts and the tapes in this case provide vital context to the defense's proffered excerpts and to the court's ultimate ruling on that proffer. Now, the reason why this central issue is unaddressed is also easy to understand. It's fatal to Ms. McKinney's arguments. As the court will recall, we initially made our request for access to these transcripts and tapes by means of an amicus brief filed before the August 31st ruling. But in that August 31st ruling, which followed many hours of argument and a 2-day hiatus in trial testimony, this court made clear that its decision was tied inextricably to not only the submissions of counsel, but also to the overall text and context of the Furman transcripts, and in addition to the tenor and tone of the Furman tapes. How do I know that? I know that from the opening paragraph of this court's order, where the court said that it had, quote, listened to the redacted audio tapes, read and considered the multiple transcripts of the redacted audio tapes. Indeed, Your Honor, in making the court's ruling, the order that was issued was so made clear that the court had been so careful in scrutinizing and comparing the transcripts and tapes that it made the observation, in line with the substantial inaccuracies comment that was made here in open court on the 29th. In footnote 4 of the court's order, the court said, quote, the court's comparison of the tape recordings with the transcripts prepared by McKinney revealed significant errors and omissions, despite Ms. McKinney's testimony that her transcripts were verbatim in nature. So we know from that the court did, in fact, not only read the transcripts, but actually listen and compare.
That's what I get paid to do.
I understand, Your Honor, and that's exactly why the public ought to be let in on what is going on and what it is that you had available to you when you issued your ruling. The reason why that's important is that any fair reading of the totality of this Court's August 31st order, which was, in fact, very detailed, reflects a significant underlying focus upon the question of whether Mr. Furman was speaking as himself or assuming the role of a character in a fictional work. In particular, one of the specifically articulated reasons for denying the defense motion with respect to at least 2 of the incidents of alleged misconduct, which were ruled inadmissible, was, and this is a quote from at least one of them, "This is clearly an instance of suggesting a scenario for the screenplay." That's found in incident number 1. Similar language is found in the Court's description of incident number 2. Similar fictional concerns obviously arose from the Court's comprehensive contextual scrutiny that were identified with respect to at least 5 other incidents, incident 1, 9, 14, 15, and 16. The fact, Your Honor, of the pre-existing disclosures and exposure of these tapes, I think highlights what Ms. McKinney's true goal is, and that is to make her attorneys into the gatekeepers of the public interest, whose exercise of discretion will be unreviewable. We join with the comments made by the City Attorney, Mr. Hahn. We believe that there is no reason why the kindness of strangers ought to be the test that determines whether or not the public or the police commission or anyone else has access to evidence which is actually before the court. Neither kindness nor sufferance are the test. The test is whether or not these are in fact public records that were considered by the court in the context of a public proceeding. Your Honor, let me address a couple of other issues briefly, and that is the following. I believe, Your Honor, that it's the height of naivete to believe that leakage, whether from Ms. McKinney or anyone else, or that leakage will not continue unabated. And I think that what we can be assured of, if this material is not publicly released, is that all of this information will come out, but it will come out in selective leaks. It will come out in dribs and drabs, and it will be pouring oil on the fires of this public controversy. And there's no reason for it, Your Honor. There's no reason for it because we can put an end to this controversy now. By releasing this material publicly, what we will do is we will accomplish 2 things. First, we will ensure that the public does understand what the basis of the court's ruling was. Second, what we will do is we will make sure that the public has access to this very important information. And why is that significant? It is significant, of course, in and of itself, because these tapes, as the court knows, have become somewhat of a cause célèbre in this city. And the impact of releasing this material and the impact on the public and the press is going to be magnified, in our view, if these tapes are not released at once, and if these tapes instead are released selectively, leak by leak. And we know it will happen because the court doesn't have access to the McKinney manuscript, the Men Against Women manuscript. Yet, I read in this week's issue of Newsweek that Newsweek has it, and they discussed it. That was the supposed intellectual property that was truly the subject of protection. But in any event, Your Honor, we know that to a moral certainty that this information will come out sooner or later, and there's no reason why it shouldn't happen sooner, because a third purpose that will be served is to ensure that the public has confidence in the very investigation that Mr. Hahn's office will be conducting, and that we have every confidence they will conduct in a fair, full, complete, and forthright manner. But unless the public has access to the information that the police commission has access to with respect to these tapes, there will be lingering questions about the fairness, the fullness, the accuracy, the completeness of that investigation, and that shouldn't happen. There's no reason why that needs to occur. Your Honor, I don't know what the court's concerns are with respect to standing, but let me just say one thing. Standing has been an issue that we addressed at the very outset. I stood here on August 31st, 1994, to address an issue before the court, which at that time was considering imposing a gag order upon the attorneys and imposing a sealing order upon the documents in this case. At that point, we brought to the court's attention Code of Civil Procedure, Section 526A, which provides for taxpayer standing. And if this court has any concerns about a corporation having taxpayer standing, although we clearly pay taxes within this county, I have a letter from Representative Maxine Waters, who sent a letter to the court on September 1st, a letter from her dated today indicating that she has authorized the ACLU Foundation to represent her interests as a taxpaying citizen of Los Angeles County in seeking access to these materials from the general public, and I can provide a copy of Ms. Waters' authorization letter to the court and to counsel. But beyond that, Your Honor, 526A, taxpayer standing, is clear. We know what that's about. White versus Davis, this 1975 California Supreme Court case, says, quote, no special showing of injury to the particular taxpayer, close quote, need be made, and that the primary purpose of the section is to, quote, enable a large body of the citizenry to challenge government action which would otherwise go unchallenged in the courts because of the standing requirement, close quote. For that reason, as well as for the fact that Article 1, Section 29 of our California Constitution provides that the people of this state have a right to a public trial, in addition to the right that's possessed by the defendant under Section 15. That is a second reason, a second basis for bringing this action. We are enforcing a public right. And, Your Honor, even the case that was cited by Mr. McKinney's, in Ms. McKinney's papers, the Dix versus Superior Court case, even though that case was, in fact, vacated by the California Supreme Court on May 31, 1990, and rendered uncitable, a violation of the rules of court and the Business and Professions Code, even that case said that, well, I'm not going to talk about what that case said, Your Honor, because that case is not authority. But when the Supreme Court addressed this issue, all that it said is, look, when it was confronted with a victim of an aggravated assault seeking standing to challenge the trial court's decision to recall the defendant's sentence under Penal Code 1170D, the court said, look, private people have no right to step into the shoes of public prosecutors. And that's Hornbook law. Nobody's seeking to do that here. The sole responsibility of the public prosecutor is the sole responsibility of the public prosecutor. The court's issuance, though, of the protective order that was proposed by Mr. Schwartz and Mr. Regwan is an entirely collateral proceeding, and if there were a violation of it, we all know that it would be a violation that would be punishable through civil contempt, not criminal contempt. Your Honor, with respect to the other issues that have been raised, let me just say this, and then I will close. With respect to copyright, there are 2 points I want to make, but 2 very important ones. Ms. McKinney never asserts, nor could she, that an order rescinding the protective order that was entered or otherwise permitting the public and the press access to the Furman tapes and transcripts could conceivably constitute any act of copyright infringement. The court simply today lifted that protective order. It would have done nothing under anyone's definition in terms of having committed any infringement of any copyright. But, Your Honor, in addition to that overriding issue, which should be dispositive of any copyright concerns that this court has, in addition to that, the issue of whether or not these are appropriately works as to which Ms. McKinney can claim a copyright is solved by reference to the Copyright Act itself. And indeed, the relevant section is cited in the McKinney opposition papers. They say that copyright subsists, and this is the law, in original works of authorship fixed in a tangible medium. That's 17 U.S.C. 101. But the key word, Your Honor, is authorship. In this case, Ms. McKinney is in no way the author, for any copyright purposes, of Mr. Furman's answers to her questions. Now, Mr. Schwartz obviously recognizes this because in his papers he says, quote, Furman's notorious comments were intentionally elicited by the skillful and creative questioning of McKinney, close quote. Now, what that is an attempt to do is to argue that somehow these answers are the creation of Ms. McKinney. But that's wrong, Your Honor. And it's wrong because in 1884, the United States Supreme Court defined authorship for copyright purposes, and this is a definition which continues to subsist. The authorship provisions have never changed, and authorship is a requirement of the Constitution in order to obtain copyright protection. Authorship means, in the words of Burrough-Giles' lithographic, quote, he to whom anything owes its origin, the originator, the maker. And here, the fact that Ms. McKinney may have fixed, for copyright purposes, may have fixed Mr. Furman's words in a tangible medium of expression does nothing to transmute her into an author of those statements. Indeed, the Nimmer Treatise, the leading treatise on copyright law, says, important as fixation is, we have just seen that originality is the essence of authorship. Accordingly, the originator, rather than the fixer, should be deemed the author. For the distinction between one poet who brandishes a quill or word processor and another who dictates to a stenographer cannot call for a differing legal conclusion as to authorship. And that's what happened here. Ms. McKinney may have an interest, a copyright interest, ignoring the Hemingway issue for a moment. Ms. McKinney may have an interest in her words and her questions. She doesn't have an interest in Mr. Furman's answers. And it's obviously the answers of Detective Furman which are the most critical key component of this issue. Your Honor, I'm not going to address the Shield Law issue. The Shield Law was ably addressed by Mr. Hahn. I associate myself with his remarks. The Shield Law goes to disclosure. It doesn't go to use. The Shield Law issue was waived. The Shield Law issue was dealt with in North Carolina, disposed of. I'm not going to deal with it here. Local Rule 719 compels this court to view protective orders like the one that was sought by Ms. McKinney with intense scrutiny. They are disfavored by this court. They are rightly disfavored by this court. The court must have found, or must find in order to preserve this, that secrecy is in the public interest, that Ms. McKinney has cognizable interests, and that serious harm will result from public disclosure. Your Honor, we believe that on all three of those points the answer is the converse. The eminent domain argument, Your Honor, is a ludicrous argument, I must confess. I honestly cannot believe that it was made with a straight face, but mischaracterizes disclosure as eminent domain. It is not. The government's exercise of power to transfer property from an owner to itself is what's involved in eminent domain. This isn't McKinney's intellectual property, and even if it were, the formal appropriation of property by transfer of a title to the government has never happened, and I'm sure never will. This isn't even a regulatory taking, Your Honor. This is, and the case that's cited, I'm amazed, the Pruneyard case, is a case which, as the Court may know, is a case in which the United States Supreme Court said that there was no taking when owners of private shopping centers are made to permit leafleters, picketers, pamphleteers, petitioners to use their facilities in order to get their expressive message out. So, Your Honor, on none of the points that have been made is there a viable argument here for keeping these materials secret, for keeping, and in point of fact, for permitting counsel for Ms. McKinney to decide selectively when the evidence that is rightly before this Court will be disseminated to the public. And we would respectfully request the Court for an order that does release these materials to the public and the press. And once again, Your Honor, as always, I appreciate the Court's indulgence.
All right, thank you. Mr. Douglas, you had a brief comment you wanted to make.
If I may, Your Honor. Your Honor, with all due respect, I've been very heartened and appreciative of the comments of all counsel, of Mr. Schwartz on behalf of his client. Respectfully, however, we now take the position, after hearing all the arguments, that given the unprecedented public interest in these tapes, as well as the importance in a full hearing of the larger community and societal issues which the tapes have raised, we believe, Your Honor, that justice is best served through the release of these tapes. We're very mindful, of course, of the interest that Mr. Schwartz has suggested. We're also very mindful, however, of what we feel on balance is the overriding public interest, particularly in some of the issues that were raised by Mr. Hahn. I think that it's very important that there be the ability to fully analyze and consider some of the very disturbing comments and implications that were raised. I've had occasion to listen to all 14 hours of the tapes and transcripts, so I have some firsthand knowledge of that which was not included in the excerpts. It is, in fact, very disturbing. There are, in fact, implications that go beyond the four corners of this particular case, and on balance, respectfully, we think that the interests are better served by the release of the tapes.
All right, thank you, counsel. All right, I need to take a recess at this point for the court reporter. We'll stand in recess for 15. I think we've heard enough. Counsel, thank you. Yes. Schwartz, you have 10 minutes to respond. Also, if you would, slow it down a little, please.
Thank you, Your Honor. First, I'd like to address what I consider to be an unprofessional swipe at me. Mr. Morrell said that I cited the Dix case against the Business and Professions Code. The Dix case was vacated on other grounds, and I cited dicta, which represents the law as it is today. And I'd like to read that portion that I cited in my brief. A person who is not a party to a criminal action has no standing to appear in the action unless a right in such party has been constitutionally or statutorily created. That's the law as it is today, and I just cited from dicta from that case. Now, Mr. Morrell also said that I didn't address the issue of what happens when something becomes a part of the public record. But I did in my moving papers. He apparently missed it. It's on page 20. I cited the case called In re Alexander. Case is persuasive authority that reasoned that while the public has a right of access to pleadings, docket entries, orders, etc., this right does not extend to information gathered in the discovery process not made a part of the public record. So the issue is, what portions of my client's materials have been made a part of the public record? Arguably, only the defendant's proffer that has been read into the record. That's only 5% of my client's material. There's other material that has been acquired in the discovery process but has not been read into the record, has not been made a part of the public record. In fact, it was protected by a protective order, and properly so. And so the public doesn't have a right to this. And we heard a lot of passionate arguments about what the public has a right to. They have to know, they have to know. But what authority has anybody cited saying they have the right to know what's in my client's proprietary materials? I haven't heard that. The public wants to know a lot of things. The public wants to know who shot John F. Kennedy, but they're not entitled to know that yet. The public wants to know the name of rape victims in several cases, but they don't know that. The public probably wants to know what transpired in private conversations on the defense's side of the table, and they probably want to know what transpired in private conversations on the prosecution's side of the table. And even though the prosecution represents the people will never find out what transpired in those conversations. They can't know. There are sealed proceedings that, in this case, that the people will never find out about because they're sealed. And this is just another example of another thing that the public does not have a right to know, my client's proprietary property. And if you take the ACLU's argument to its logical extreme, they can come in here with their taxpayer status for standing and argue that the public has a right to know how Mrs. McKinney decorates her home, and so they can just march into her house and start taking pictures off the wall because the public has a right to know. That's absurd, yet that's what they're trying to do with my client's proprietary information, in which she does enjoy copyright protection. And this seems to me to be the tyranny of majority. Everybody's coming in here clamoring that they have the right to know, and based on that, because everybody's in agreement, my client has to forfeit 10 years' worth of intense creative labor. And the other argument that the ACLU put forth, which is kind of ridiculous, is this idea that it's going to leak anyway. This leakage is going to happen. We all know it, so why don't we just get it over with and turn over the whole thing? Well, I guess if somebody's dying of cancer, we should just shoot them in the head since they're going to die anyway. I mean, forget about trying to cure cancer. And of course, they're saying that by lifting the copyright, by lifting the protective order, the court would not be engendering a copyright infringement. But really what the court would be doing is putting my client's information on a silver platter and ringing the dinner bell for everybody else in the world to attack it and distribute it and reproduce it in whatever form they so desire. And if I may just come up with a creative metaphor to illustrate the point, if I were to take a rabbit by the ears and drop it in a rattlesnake tank and turn around and say, well, I didn't kill the rabbit, the snakes killed the rabbit, we all know that would be wrong because I killed the rabbit by dropping it into the tank. And by lifting the protective order, the court would effectively be killing the rabbit because they're putting it out there for everybody to attack and to use without my client's permission. And let's talk about Mr. Furman's words for a second. They're still claiming that my client doesn't have a right to those words. Well, she doesn't have a right to his words, but she has a right to the sounds that she transfixed into this medium of expression called an audio tape. She does have a right to that. And we, although we fervently contend that Mr. Furman does not have a right in his answers that were recorded on tape, I'd like to point out that Mr. Furman entered into a contract with my client where he would get $10,000 in exchange for doing all this. And so he forfeited whatever rights he had in favor of my client. And they said that my eminent domain argument was ridiculous. But if this court sees fit to completely devalue my client's property by setting it up on this silver platter, of course that's a taking. And to the extent that the ACLU says it's not a taking, we know now what ACLU really stands for, another constitutional law undermined. And let's talk about authorship for a second. Let's take two famous cases of authorship. Abraham Zapruder caught the Kennedy assassination on film. Fortuitously, he was standing on a hill and he filmed the assassination. He caught that on film. Now, he doesn't have a right to stop people from reenacting the assassination, but he certainly has a right to that film, and he sold it to Time magazine. And George Halliday, when he videotaped the Rodney King beating, he didn't participate in the beatings himself. He didn't tell the police what to do. He just ran outside and taped it. And he has a copyright in his videotape. And now with the Furman tapes, my client, unlike the Halliday case and unlike Abraham Zapruder, my client overtly participated in that conversation. Mr. Furman would not have uttered those words if it wasn't for my client's questions. She actively participated in that and skillfully elicited that information and recorded it. And the recording is where you have authorship. It's not the fact that he said it, it's that she caught it on tape. And she is an author simply by virtue of the fact that she flipped on her tape recorder. If I took a picture of this courtroom, I would have a copyright in that picture. Thank you. And likewise, when she started her tape recorder, a copyright interest was created immediately therein. I'll address the city's argument for standing. They may have a standing because they need to conduct this investigation, but the question is, do they have standing in this proceeding? And they don't. And in fact, no charges have been filed against anybody. And if they need information for an investigation, for charges, then I understand that. But still, they need to go to a grand jury and get an indictment or something. No charges were filed based on the Furman tapes. And they need to initiate their own proceeding. And they do have subpoena power in another action. And we'll handle it, and we'll take it up at that proceeding. And they've actually served that subpoena. So they don't need this court to do that in. I think that they're trying to use this court because we otherwise might be able to raise the shield law, which Mr. Simpson could overcome, but they can't overcome that. And we contend that we haven't waived any protections afforded by the shield law because of the protective order. The information was used as far as it was needed for the Simpson case, but to the extent it could be used for something outside this case and unrelated to this case, for example, an investigation, she is still entitled to invoke that shield law. The city says that it would pose an administrative burden on them if they were to have to continually come back to our office to conduct their meaningful investigation. But I am aware of no authority which purports to be a law of convenience, allowing a governmental entity to subjugate the property rights of my client, just so they can make life easier on their employees. My client has property rights that have to be respected, and we're sorry that it may cause an inconvenience to anybody, but that inconvenience doesn't give them the right to come in and demand wholesale copies of my client's materials. And they argue that it wouldn't be a copyright infringement for the city to have these materials because they're not going to be distributing them and they're not going to be reproducing them, but it would be a copyright infringement for the court to give a copy to them, because that infringes on my client's right to distribution, even if it's just one copy to one person. My client has the right to do that. The court doesn't have the right to do that. The court has the absolute right to use my client's copies of her work for these proceedings as it has ably done. But for matters that are outside the scope of this proceeding, the court has no authority to start giving copies of my client's work to anybody who comes in here and demands them. Also, I don't know how much more of an investigation with regard to my client's tapes is necessary for the city. I mean, they've already heard everything that's on there. They pretty much got the gist of it. As I said before, they're welcome to come back. But a meaningful investigation can be accomplished at this point by using that information now. Go ask Mr. Furman some questions. Go ask the victims of these alleged incidents of police misconduct. Open Mr. Furman's files, which I understand are sealed and sent off to Sacramento. I mean, there's a lot of things that they can do now for that investigation. They don't need my tapes anymore, my client's tapes anymore. They can use that information that they've already garnered. If they need to come back, they continue to look at it. That's fine. But they can show the public that they've already started their investigation. We will continue to help because we realize this is an important thing. And then they can start with the rest of their investigation. They don't need to have a copy of my client's materials. And unless the court wants me to address any other issue, then I would again just pray that the court respect the protective order, which was properly enacted. I guess if I may, I'll just address why the court's protective order was proper.
Well, I think you can assume that would be a persuasive argument since I issued it in the first place.
Okay. The local rule was brought up by the ACLU 7.19, saying that we haven't satisfied 3 requirements for the protective order. The first requirement is that secrecy is in the public interest. The second requirement is that my client would have to have a cognizable interest in the materials. And third, that serious harm would result from a public disclosure. Secrecy is in the public interest, Your Honor, because to protect these materials would protect the reasoning behind the copyright law in toto and the Shield law. Because for the copyright law was enacted to give authors a monopoly on their work, to give them an incentive to keep creating. That's why we grant it. And if we don't respect that monopoly, if we don't respect that protection, then the public's interest in promoting the arts and sciences will be derogated. We want to protect this copyright so that we can send a message to all other authors that, hey, you will be protected if you create your works. The second factor, that my client has a cognizable interest in the materials. I mean, even the ACLU would all but concede that at least my client has a right to her spoken words. And that's about half of what's on the tapes. And this tape recording, or these tape recordings, are not indivisible works. Excuse me, they aren't divisible works. It is an indivisible work. You cannot just go through there and redact one person's words. This is one unit, and my client owns it. And the third factor is that serious harm will result from a public disclosure, and serious harm would result from a public disclosure at this time without my client's permission, and that would be, of course, the complete devaluation of 10 years' worth of creative and physical labor. And for that reason, Your Honor, the court's issuance of the protective order was completely proper, and it should not be undermined at this point. And so again, unless the court wants me to address another issue that it is still considering, I would ask the court to uphold the protective order and to deny the motions of these non-parties.
All right. Thank you very much, counsel.
Thank you.
All right. Let's shift gears. Counsel, I'm going to take the matter under submission. It's not a matter that I need to address immediately. I do need to get my rebuttal case underway, so you can anticipate a ruling sometime next week. All right. Thank you, counsel.
Thank you, Your Honor.
All right, we have 3 issues before us with the counsel for the real parties and interests. The list of rebuttal witnesses, I do have before me a letter, 2 letters from the district attorney's office, both dated September the 8th. In the first letter, there is a list of 59 rebuttal witnesses.
Argue these issues with the court. I just returned to the courthouse. I've been gone all afternoon, but the letters that the court just indicated are most recent additions. I'll attempt to assist the court and Mr. Douglas the best I can.
All right, are Ms. Clark and Mr. Hodgman en route?
I'll try to reach them, Your Honor.
You should find them.
All right, well, I mean, we've got, okay, well, you've got the list of potential witnesses. Mr. Darden, do you have any information as to, my understanding is you're going to start with certain photographers who've allegedly taken photographs of Mr. Simpson in the wintertime wearing gloves?
That is a probability.
Your Honor, I heard the court said, I know Ms. Clark anticipates arguing the rebuttal on the blood evidence that we just had.
Though I'm just trying to figure out who the next several witnesses are going to be. But how about if you get them down here?
I'm trying, Your
All right.
Perhaps Mr. Dodd can talk about the 59 names since he signed that letter.
Well, I assume that since they've told both myself and the jury that they have approximately 5 days worth of presentations, that this is a list of potential witnesses given how things go. For example, Bruce Weir.
Well, of course, we may need him for for additional numbers, so that's why it's on the list.
As you know, there's a serious issue with respect to the
Scientific.
RFLP results from the Bronco, whether that comes in on the rebuttal case that we have to address today. And I submit to you that Dr. Weir absolutely would be necessary if they're going to be allowed to put that in. And then Dr. Shields is going to be a witness in rebuttal, and Mr. Sims is necessary for it. And I think that there's a serious issue there as to whether or not they can present that at all.
All right.
That we have to address.
All right. Record reflect that we've now been rejoined by Ms. Clark and Mr. Hodgman and Mr. Yokelson.
If the court pleases, Your Honor, can I deal with the lay witness issue and then leave to Mr. Scheck the scientific witness issue?
Sure.
Or Mr. Neufeld?
Sure. Certainly.
This is part 3 of this day, and it's the shortest part of all of them. So it's an hour and 29 minutes. We've already done a few minutes of it. I don't know if we'll finish today, but
My colleagues are prepared.
we'll finish
to answer
this
the court's
long
questions.
day tomorrow.
All right. Counsel, we anticipate beginning the prosecution rebuttal case Monday morning, promptly, I hope. Who do you anticipate now that you've had some time to contemplate these matters
The next video is Monday morning.
and the other issues have been resolved by the Court of Appeal?
We need to, I believe that the court wanted to take a waiver from the defendant.
That'll
Correct.
take all of 30 seconds.
Okay. Are we going to do that today, or?
I would assume shortly before, out of the presence of the jury, but before we resume on Monday.
Okay. And then we intend, as I indicated to the court, to begin with the glove photos.
All right. Who are your glove photo witnesses?
Mr. Hodgman has the list on for that. Gordon Bella. Gordon Bella. Karen Brown. James Chegia.
How do you spell that?
Chegia. Correct. Deborah Guidera. Mark Kruger.
Kruger is on the 27 on the witness list.
Mm-hmm. And Richard Rubin.
All right. The
William
first.
Rankin.
Rankin?
Yes, Your Honor.
What is this person's role?
William Rankin is another person with the glove photographs.
Do you intend on calling all of these photographers?
To lay the foundation. It's about 1 minute of questioning. Did you take this picture? Yes. When? That's it.
Where?
Where? And where? I mean, the total sum of all the photographers, the number of them is about 10. Their questioning will take about 5 minutes each, if that. And that's it. It's just a foundation for the picture.
All right.
Richard Romano. Richard Roman. Michael Romano. And I said Richard Rubin. Kevin Schott. Rob Seib, S-E-I-B. That's it. And an NBC representative.
All right. After you conclude with the glove photo witnesses, who do you anticipate using after that?
After that, we intend to call Gary Sims.
As to what issue?
That's the blood in the Bronco, the RFLP result on the console.
All right. And are you going to need to recall Dr. Weir?
We need to address the court on that matter.
And what is the status of the DOJ RFLP?
4 probes. There was a 4-probe match to Ron Goldman and the defendant.
As to each?
It's a mixture. I think it's as to each. I'm not prepared to address that, Your Honor. That's going to be addressed to the court by Brian Kelberg. I assumed
right.
it would be Monday.
I would suggest then that we set for a hearing Monday, probably at 5, because we have that issue of the timeliness of performing the RFLP. That's been raised.
Okay.
All right.
We received another or read this afternoon. And the problem I have is that anticipating that we were promised a report from Mr. Boziak, we haven't gotten it. I got a report yesterday from Mr. Popovich. Glove photographs were supposed to be turned over, haven't been turned over.
Counsel, let's take this up one item
All
at
I'm
a time.
saying is that I would prefer, and I don't see any reason why it shouldn't be done, that we address this now. I'm prepared to argue it. We're scheduled to be argued. It's not fair to dump all this discovery at the last minute on us. We're going to ask for adjournments. I'm telling you right now, we're going to ask for adjournments because they've been playing with it. They had this stuff.
All right,
they haven't been
counsel.
turning it over. If we can eliminate this
I've
and
heard
resolve
enough.
this issue.
I've heard enough.
Okay.
Thank you. All right, Sims, then probably who? Weir?
Well, depending on the court's ruling, that's what we're going to need to address with the court, as to whether Mr. Sims can be allowed to do the numbers. And then Brad Popovich. Now,
Popovich was who? Refresh my recollection.
Brad Popovich is,
Oh, this is DNA, PCR lab stuff.
correct, response to Gertie's.
All right, and then what topic are you going to move to after that?
Then we're seeking to admit the Thano Paratus video under 1202 of the Evidence Code.
The Paratus, okay. That should take all of about 5 minutes.
The Paratus video? Correct.
Yeah.
Yeah, that's very good.
Okay,
Right.
correct. But if you recollect, we had a long discussion about this.
Right, right. The Ackards, I think it was Lawrence Ackard and his wife.
As to what issue?
That goes to Robert Heidstra.
What's the wife's name?
Pardon?
What's the wife's name?
Heidstra.
It's the wife's name. She's not on the
Right. Patricia Beret also goes to Robert Heidstra.
This is the person in the pet shop?
I'm sorry, and Christian Anderson. I'm sorry.
Was this the person in the pet shop? Or the
Sure.
pet hospital?
Yes, Your Honor.
Yeah,
All right, and who was the other person? After Beret?
Christian Anderson.
Anders.
Right, and that's another witness who received a prior inconsistent statement from Robert Heidstra. Yeah, George Field, number 20, another Heidstra witness.
All right, where do we go after that?
After that, Dr. Don Dutton.
Dr. Don Dutton? As to what issue?
As to pre- and post-homicidal conduct of murdering spouses.
I sense a 402 hearing.
Yes, that may be so. He will be addressing the demeanor witnesses called by the defense, if the court recalls.
All right, if you would, put together your P's and A's on that,
On
both
Dutton.
sides. On Dutton.
Can I get an offer of what to testify so I'll know how to address it?
Did you have a report from Mr. Dutton, or any works or a CV from Dr. Dutton?
I have a CV, any notes or anything?
The defense has his CV. With respect to his proposed testimony,
My
we will be
computer
meeting
just
with him
completely
tomorrow.
froze.
And I will
I
put
don't
together
know
an
if
outline of what he proposes
this
to
was
testify
streaming
to.
for the last few minutes,
Okay, off the top of your...
but my computer just completely just froze. And I was trying to get to the chat. Oh, no, I can see chat now. Froze. I was trying to get to the chat on my phone, but I can't. YouTube doesn't show your current live stream in the studio app on the phone. You can't get there. One way to do it is to do it by name, video name. You can sort of look it up like you would a video, except all of my OJs have the same title. So that would not have worked. But yeah, I don't know what happened. I don't know what's going on. But yeah, we're back. I'm just gonna not touch a darn thing at all until we get through this stream.
Your head, though, I mean, I'm sure you've had preliminary discussions where you've decided you may call him. Can you just give me a heads up as to where we're going with that?
Yes, what he has done, Your Honor, is he himself has done a study interviewing men who have murdered their wives and reviewed their cases to determine what their pre-offense behavior was, their demeanor, and their post-offense behavior was. And it goes to the issue of what one would expect to see in their demeanor.
Has Dr. Dutton been allowed to testify in any other courts with regards to this?
I don't know.
With regard to this?
You know, I hate to make a representation to the court. My sense of it is that he had. He's certainly very well versed in the area as to what kind of behavior is to be expected, given his studies and his involvement in the field. But I need to get with Dr. Dutton tomorrow to make sure of that.
All right, I'll need to see P's and A's on this. Okay, what do we anticipate going after that?
We appreciate the difficulty in our ability to respond yet until we have a chance to understand more.
But I think the issue is pretty clear.
An additional area of inquiry of Dr. Dutton would be a victim's profile to debunk the myths.
And what's that rebutting, Your Honor?
And that goes to the testimony elicited by the defense from
You think?
Simpson,
You
Christian
think?
Reichardt. Who else? Those two witnesses, though, concerning the behavior of Nicole Brown in the time before her murder, her conduct with the defendant. What the defense is going to argue, based on their testimony, Your Honor, is that there were no problems between them because, after all, she was still friendly with him, she was at the house with him, and she had nothing to fear from him. That is a myth that can be uniquely addressed by someone involved and an expert who is an expert in the field of domestic violence, as Dr. Dutton is. He will be able to discuss the fact that the typical battered spouse syndrome, or the battered spouse, doesn't necessarily run away and stay away from the spouse who is doing injury to her, of whom she is afraid. And that would go to address the issue specifically raised with Arnell Simpson's testimony that she saw Nicole sitting on his lap just weeks before the murder, and Christian Reichardt's testimony concerning the nature of their relationship on and off again, coming back to each other, leaving each other.
All right. Where do we go after Dr. Dutton?
And with respect to where we go with after Dr. Dutton, Your Honor, we will be filing a brief with the court, and we are going to ask the court for the ability to bring in the evidence in the study prepared by Doug Diedrich concerning the rarity of the bronchofibers. We believe that the defense has opened the door to this in two ways. Number one, that in his questioning of Kathleen Bell, Mr. Bailey brought up elicited from her a description of the vehicle driven by Mark Furman, which was a pea green and white utility vehicle. There was no effort made by Mr. Bailey at any time to verify that that was indeed the vehicle Mark Furman drove at that time. I'm sure the proffer would be from him that he attempted to elicit that to show that she could identify Mark Furman, that she did know him, in order to impeach the testimony he gave that he did not remember her. However, without an effort made by the defense to tie that vehicle into Mark Furman, what the purpose of that was, and I bet the argument will be forthcoming, that he had a predilection for that kind of sports utility vehicle, similar to a Bronco. So that's one area in which I think. The other one is the general attack upon the credibility of Mark Furman. In that regard, it was the Bronco fiber that was found on the Rockingham glove. That goes to impeach, but that does go to reinforce the fact that it was not planted, that it was indeed tied to the defendant through the fiber from his car.
Okay, well, put your P's and A's together and we'll, but I'd like you to also include in your P's and A's cites to where it is in the transcript so I can
Yes, we
find it.
will.
Okay. All right, and then where do we go after Mr. Diedrich?
And Your Honor, this is all within 5 days?
Well, the photographers are going to go, I assume, very quickly.
Mr. Diedrich will address the fabric impression on the envelope to which Dr. Lee testified.
I'm sorry, is that Diedrich or Bozak?
Diedrich,
Fabric impression, that's on the, I'm sorry, on
I think
the,
it's on the envelope. My memory serves me it was on the envelope.
Okay.
Parallel lines that Dr. Lee testified to, which
Okay.
he thought might be consistent with a shoe print, but which we had determined, I think we have determined, we haven't gotten the report yet, to be consistent with, I believe, the jeans of Ron Goldman. And Bill Bodziak to address the shoe prints testified to by Dr. Lee.
okay. All right, well, that ought to take a couple of days. All right, Mr. Scheck and Mr. Douglas have raised certain discovery issues regarding these matters, and the most difficult, of course, being the scientific witness matters.
All right, may I make one small suggestion first?
Certainly.
Which is that on this list of 60 witnesses, there are, since there's no indication whether someone is a PhD or an MD or an expert in any field, what we need to know for obvious reasons right now is who on this list of 60 people are intended to be experts. You've, of course, elicited from them several, but there may be many others. One person I see on the list, for instance, is a psychiatrist.
Saul Fairstein?
Yes, although it's not indicated here. What I would ask is, especially if it's the people's position that they intend to complete their rebuttal case in 5 days, given a list of 60 witnesses, and given the obvious limitations that we have in being able to prepare cross-examination of these 60 witnesses, and the special problems that arise when you're dealing with experts, notes, reports, 402 hearings, FRI hearings, and the like, at a minimum, Your Honor, today, so we don't waste a moment over the weekend, we would ask the court to find out from the people of the list of 60, who do they intend to elicit expert testimony from, and then as to those people, at least a proffer. So, because we, as Mr. Scheck was pointing out earlier, we need to know what's realistic so we don't go off on wild goose chases in the very short amount of period that we have to get ready for these witnesses.
And as to lay witnesses, Your Honor, we'd like names and addresses because some of these names are new to me.
What concerns, we're just really concerned with the suggestion that this is all going to happen within 5 days. And this list is inconsistent, frankly, with that representation. So at a minimum, Your Honor, right now we need that. We need to know who the experts are, and a very brief proffer, not an extensive one, but just the kind of thumbnail sketch that you asked for so we can know where we stand.
All right.
I wish to remind the court that this comes from the team that repeatedly gave us people on the short list who were never called. People that I have prepared for extensively who were never called, and I didn't find out that they were not going to be called until yesterday. So I just want the court to get a
I
sense.
have my own list of witnesses that we haven't seen, so
Right, okay.
I understand that. But
In order
But
to...
as you know from our conversation yesterday, Ms. Clark, my biggest concern is finishing this case with an intact jury. And delay is something that will be anathema next week.
I agree with you. I think all of us share that concern, Your Honor. There's no question about it. In order to avoid being precluded by failing to give notice, however, we felt it very important to be as inclusive as possible. We don't want to be caught short that way. With respect to who are the experts,
All right, why don't we go down the list and let's identify who the experts are.
Michael Bodden.
All right.
Michael Bodden would not be called for expert testimony. I think I should give that to the court. Michael Bodden, Saul Fairstein, obviously experts. They would be called for the events of June 17th.
What's the profit for that, if I may ask for it, Your Honor?
We're talking about the chase.
Recall there being any defense case witnesses that would have raised that issue so as to make this a proper...
Well, that's a scope issue. What we're going to do is identify experts.
Very well, Your Honor.
All right, we're not at the scope issue yet.
Yes.
Okay. I'm not turning my camera on because I'm scared.
Okay.
We made it 23 minutes into this, so we have an hour tomorrow to do. And then we'll get on to Marcia's witnesses. And tomorrow we'll hit video number 444. 4. We're getting there, guys. Thank you so much for coming out today. Sorry my computer froze. Well, you know. I shall see you all again at 8 p.m. Eastern Standard Time. Have a great day, guys. Bye.